There's a lot of people in the comment section just recently that are very worried that the laws of the United Kingdom do not allow you to defend yourself. But that's not quite true. Although you can get into trouble if you go too far, but that's what I'm going to explain in this video in more detail. But if you're new to me, I am Daniel Shensmith, a barrister of England and Wales, and I really enjoy to help you understand law, so I'll be really grateful if you bop that like button on the way in and subscribe at any point that you find this video useful. Or right now, if you're feeling really cheeky. So let's get into it. What is self-defense all about and what is reasonable force? So as I explain this, I'm going to give you an outline of what reasonable force is, when it can be used, and dispel the myths that you can't actually defend yourself, and answer some of the questions along the way. And just as a heads up, I'm also going to introduce you to a rather unique opportunity to learn some self-defense skills that are taught to the military and elite special forces. More about that a little bit later. So what is self-defense and what does it entail? Well, as the name suggests, it is a defense to something that might otherwise be a crime, such as the use of force against another person. So if you were to injure somebody else and you said, I was only doing it to defend myself, then it is self-defense. It is the defense of self-defense, and it's a full defense. And the burden, contrary to popular belief, is not on you to prove that you are acting in self-defense. Whilst there is an evidential burden, i.e. you must raise some evidence that you were acting in self-defense, and that's usually your own evidence. You stand up in court and say, I did it in self-defense. And then the burden shifts back to the prosecution. That is, assuming you were charged with the crime for hurting another person, which may not actually happen, because in reality, and if common sense prevails, in the majority of circumstances where people have used reasonable self-defense, then you won't be charged with the crime in the first place. And that's where the common sense really should kick in. So self-defense hangs on a two-part test, on all of which is based around this concept of the reasonable and sensible use of force when necessary. Now, the principle of self-defense was first set out in a case called Palmer of 1971 and was approved by the court in other cases. And this is a common law approach. Watch the comment section go crazy, but it's a common law approach in that judges have made these determinations, and that is how that it is applied moving forwards. It is also reflected in other sections of law, such as Section 3 of the Criminal Law Act 1967. A person may use such force as is reasonable in the circumstances in the prevention of crime, or in effecting or assisting in the lawful arrest of offenders or suspected offenders, or of persons unlawfully at large. And the key wording there is any force that is reasonable and is also inherently necessary. And the use of said force, as suggested by the common law approach, is either in self-defense, literally defending yourself, defending another person, which is sometimes referred to as self-defense of another, which is a bit of a misnomer, but that's essentially what it means. Defense of property. I'll come back to that one in a moment because that is distinguished very slightly in householder cases, which I'll also explain throughout this video. The prevention of crime and a lawful arrest. Lawful arrest, by the way, might be an arrest by a constable, and it might be arrest by any other person as per Section 24A of the Police and Criminal Evidence Act 1984. Commonly referred to as a citizen's arrest, which necessarily uses force, reasonable force, to detain somebody for an indictable offence. Now, this brings us on to the two-part test and what the two-part test means. The two-part test is partly subjective and partly objective. The subjective part, what did the individual think? And the objective part, what would a reasonable person think? And the way we apply it is as follows. We first ask the question, was the force necessary in the circumstances that the defendant genuinely believed them to be, assuming they've been charged for an offence here? So in other words, was it necessary to use any force at all? That is the subjective part. The magistrate or a jury are asked to decide whether or not the defendant genuinely believed those circumstances called for the use of force. Was it necessary? and it is those circumstances they genuinely believe them to be. They might be mistaken. Now, there are various rules about mistakes, such as how ridiculous the mistake is and whether they were intoxicated, in which case they can't rely on mistake. But generally speaking, even if it's a mistake, the question can still be asked. If they genuinely believe those circumstances at that time, that part of the test is satisfied. Then we move out to a objective test with regard to the use of force in those particular circumstances. Would a magistrate or jury accept that it was reasonable force on an objective, what would a reasonable person think, in those circumstances? And if that is answered in the affirmative, then the defence of self-defence is made out, and it is a full defence. And it's a full defence to any kind of use of force at all, including killing somebody. If you genuinely believe that the circumstances were that someone else was going to kill you, and firstly, you believed that the use of force was necessary, and given those circumstances, the most extreme of circumstances, you acted against this person and ended up killing them, a jury might well find, if you were accused of the offence of murder or manslaughter, the jury might well find that your actions in those circumstances were perfectly reasonable, given the circumstances that you genuinely believe them to be. Now, there are some impact factors that might negate this. For example, if you chased them down the street and then, for argument's sake, shot them, that is not likely to be reasonable force because you chased them away. You're no longer acting in self-defense because you've chased them off. But if they are still in your home and you are protecting yourself and your family, and that happens, then of course it might well be deemed to be reasonable if indeed you were charged at all. This is why it's always important from the very first opportunity to say why you did something, because, as the caution goes, it may harm your defence if you fail to mention when questioned something that you later rely on in court. So if you were acting in self-defence, even if you severely hurt the person, then that is what you should say. You were acting in self-defence, because then you have a consistent story all the way through. Now, what about some questions such as, do you have to wait to be attacked before you respond in self-defence? Well, the simple answer to this is no. There's no rule in law that says you must wait to first be struck before you defend yourself or another or your property. But of course, all of the facts and circumstances are always taken into account depending on what you did in defending yourself, remembering at all times that it does need to be reasonable force. So how about acting in revenge? Let's say you went somewhere to exact revenge and then you hurt somebody. Well, this has been held to not necessarily rule out the possibility of the defence of self-defence if violence ensued afterwards, if you did go out to seek revenge on somebody. It's not necessarily unavailable as a defence, but generally, if you are the one that sought out the confrontation in the first place, i.e. the person who is the aggressor that starts the violence in the first place, they generally cannot rely on self-defence. And so before we get into defending your home and what level of force you can use there, watch this short clip for a course coming up on the 16th and 17th of September, which is linked below, few places left. Please click the link and sign up if you want to learn some proper self-defense skills that are generally taught to the military and special forces. Take a look at this.
You come, I'm like extend, mate. You can feel it, can't you? Yeah, there's something there, yeah. Out to 90, just push the person back. And I go low. Bang! Straight in there. Look how I cut in. Look how I cut in and drag him down. Bang!
It's definitely exceeded expectations. Close quarter combat, self-defense.
Yeah. Because if I grab there, he's going to drop back if you could, but he can't, because that's there. Got it? Yeah. What? I grab, bang! I'm on there. As soon as I got the attack, look at that. I'm leading that straight in. Yes? Yeah. You feel it, can't you? I'm feeling it. Right. Now, is that better?
Yeah, that's okay. All good.
Now watch. His brain's trying to figure out how to do this, how to stop it. So what I do is I move the body. Now he's concentrating on landing rather than anything else. Got it? Yeah? You know.
Lawful use of force, and weapon drill.
What the Japanese do, they go for the can shoots, and this is can shoot, they go to that movement there. Different there.
Yeah, no, I signed up for like a bit of personal development training. This exceeded expectations, and I can't wait to come back.
To good depth that could be fitted in the time we had. So yeah, really enjoyed it.
And so back to self-defense and defending your home. Now, there is a very useful joint statement by the Crown Prosecution Service and the National Police Chiefs Council, which I will read to you, because it's the definitive word on this as a joint statement, and it's very useful to understand just how you can protect your own home and family. The guidance starts out with an explanation of what the purpose of the statement is, and says as follows. It's a rare and frightening prospect to be confronted by an intruder in your own home. The Crown Prosecution Service and Chief Constables are responding to public concern over the support offered by the law and confusion about householders defending themselves. We want a criminal justice system that reaches fair decisions, has the confidence of law-abiding citizens, and encourages them actively to support the police and prosecutors in the fight against crime. Wherever possible, you should call the police. The following summarises the position when you are faced with an intruder in your home and provides a brief overview of how the police and CPS will deal with any such events. Does the law protect me, and what is reasonable force? Anyone can use reasonable force to protect themselves or others, or carry out an arrest or to prevent crime. You are not expected to make fine judgments over the level of force you used in the heat of the moment, so long as you only do what you honestly and instinctively believe is necessary in the heat of the moment. That would be the strongest evidence of you acting lawfully and in self-defense. This is still the case if you use something to hand as a weapon. Now, pausing for thought there, because lots of people have said that you can't use some kind of weapon to defend yourself, whether you're out in public or whether you are in your own home. Now, this is obviously going to be impacted somewhat depending on whether you took it with you as a weapon and had the intention beforehand to use it for self-defense, to harm somebody, because there is no technically legal self-defense weapon available. But that's not necessarily to say that you can't use something as a weapon in self-defense. For example, if I were to pick up a tripod here and say that I just happen to have this with me when I'm out filming something, someone attacks me and I use it as a weapon to hurt somebody, so long as I genuinely believe I was going to be attacked and that force was necessary and that hitting them with something was reasonable in those circumstances because they were going to hit me with something, that's perfectly fine. However, if you obviously take out something which is designed as a weapon or a knife or something and say that you're using that for self-defense, that is going to hinder your defense of self-defense. So that is the warning that I always give on this channel. So think about that in conjunction with this guidance. What amounts to disproportionate force? I've heard I can use that. This statement goes on to say, the force you use must always be reasonable in the circumstances as you believe them to be. Where you are defending yourself or others from intruders in your home, it might still be reasonable in the circumstances for you to use a degree of force that is subsequently considered to be disproportionate. Perhaps if you are acting in extreme circumstances in the heat of the moment and don't have a chance to think about exactly how much force would be necessary to repel the intruder. It might seem reasonable to you at the time, but with hindsight, your actions might seem disproportionate. The law will give you the benefit of the doubt in these circumstances. This only applies if you are acting in self-defense or to protect others in your home and the force you use was disproportionate. Disproportionate force to protect property is still unlawful. And that's where we get on to the subtle distinction with property. You cannot use disproportionate force to protect property. Some of you might disagree with that. Let me know in the comments. However, the use of disproportionate force against a person in your home is still deemed, on occasion, to be reasonable. As long as you believed it was necessary at the time, and it's perhaps deemed to be reasonable, even if it's disproportionate. But then this statement goes on to talk about grossly disproportionate force. What does that mean? This statement describes that if your action was over the top or calculated action of revenge or retribution, for example, this might amount to grossly disproportionate force for which the law does not protect you. If, for example, you had knocked an intruder unconscious and then went on to kick and punch them repeatedly, such an action would be more likely to be considered grossly disproportionate. And ultimately, that means your self-defense argument is going to fail. And then this statement goes on to talk about some of the other things that I've already talked about in this video, so I will link below the full document so you can go and read it at your leisure. So I hope that serves to dispel some of the myths that you quote-unquote can't defend yourself in the UK, England and Wales, where this video is focused for the avoidance of doubt. And I hope you now feel somewhat easier that you can defend yourself. It just has to be sensible in the circumstances you genuinely believe them to be. It can't be over the top, even if you're defending your own home. And you can use a weapon depending on the circumstances. But as I say, the level of premeditation and whether you go out with a weapon in hand might well hinder your argument of self-defense. But nonetheless, I hope you found that interesting. Please do remember to hit that like button and subscribe. Check out the course linked below, 16th and 17th of September, coming up quickly in under 10 days' time. Sign up for that course if you haven't already, and thank you for watching, and I'll see you next time.